be seated. Okay, good afternoon. We are here outside the presence of the jury. The jury has been dismissed for the day to review jury instructions. Attorney Kinney, before lunch, before we broke, you did make a motion. Would you like to state that further on the record?
Yes, Your Honor, just briefly, thank you. I'm moving to dismiss all 4 charges for insufficiency of the evidence, even when viewing the evidence in a light most favorable to the state. No rational trier of fact could find beyond a reasonable doubt that the state's presented sufficient evidence to overcome their burden of disproving defense of others with respect to all the charges. Specifically, and I'm looking at paragraph 2 of physical force in defense of a person, 627:4, subparagraphs B, C, and D. We concede that A is not applicable, but B, C, and D, based on the evidence presented, are all applicable. Specifically, a person is justified in using deadly force upon another person when he reasonably believes that such other person, B, is likely to use any unlawful force against a person present while committing or attempting to commit a burglary. And that would be the evidence here that Caitlyn was restraining Ellen, using unlawful force against her, and not leaving the home when Dustin was telling her to, because her purpose was either to kidnap the child, interfere with custody and bring her across state lines, commit theft by extortion, or theft by deception. And that would be the facts related to her coming to the apartments, overstaying her welcome, demanding money, making threats that she's going to take the kids and Dustin will never see them again. Excuse me. C is committing or about to commit a kidnapping. Again, with about all those facts that we have alleged through the state and through Mr. Duren's testimony, that her behavior and her comments show that she was about to or intending to commit a kidnapping. And D is likely to use any unlawful force in the commission of a felony against the actor within such actor's dwelling or its curtilage. And I don't believe I misstated this earlier, Your Honor. I would argue that I got it right, but the unlawful force is Caitlyn using unlawful force against Ellen while committing a felony against Dustin within Dustin's home. And that felony being any of the ones that I enumerated already: interference with custody, kidnapping, theft by deception, theft by extortion. And so for all of those reasons, we have presented evidence the state has not overcome, and the court should dismiss all 4 charges.
Okay, thank you. Counsel?
Your Honor, I'll ask that this court deny the motion. I believe the court already did deny it. I'll ask it to make that record clear. I'm going to cite the state versus Perez. Does not yet have a formal citation. It's 2025 New Hampshire 6, dated February 7th, 2025. And in state versus Perez, the Supreme Court discusses the standard that applies in a sufficiency challenge at the close of the state's case and after the close of the defendant's case as well, when the defendant has presented evidence. The court says that evidence presented in a defendant's case in chief could tend to disprove or discredit the evidence introduced by the state. Nonetheless, this type of evidence is immaterial to the trial court's analysis, because the trial court must view all of the evidence and all reasonable inferences from it in the light most favorable to the state. Consequently, the trial must construe conflicts between the state's evidence and the defendant's evidence in the state's favor when it's analyzing the sufficiency of the evidence challenge. Accordingly, the trial court's analysis of whether the state introduced sufficient evidence to prove the defendant's guilt would be the same regardless of whether it is conducted in response to a motion raised after the state rested its case or at the close of the evidence. That is the controlling law here. With regard to the facts, again, the standard is in the light most favorable to the state, whether or not there is sufficient evidence for properly state that double or triple negative that we discussed before, but there is certainly sufficient evidence for any rational trier of fact to find in the state's favor here. I think be straight into a bit of a charge conference there with defense counsel's argument, but with regard to each of the different varieties of justified force in defense of a person, I think the state has certainly presented the necessary evidence for a rational jury to find that the defendant did not act in self-defense. I'll note for the court at this time, I'm sure we'll get into this more, but I'm going to quote from my notes here of what the defendant said during direct examination and his cross. Defense counsel just, I'm not sure why, but defense counsel just said that they don't believe they're going to make an argument about subsection A, where someone is about to use unlawful deadly force against the actor or a third person as a reason for justification. My notes indicate that that is exactly what the defendant testified to, and that's the only thing he testified to the exclusion of other reasons. The defendant said, again, these are my notes, so it's words to the effect of, he shot the victim because she hurt Elowen. During the testimony about the multiple attempts to take Elowen from the victim and take Elowen from Caitlyn, there was that third attempt that was unsuccessful, and at that point, according to the defendant today, a line was crossed. Elowen was being physically hurt in front of me. My threat level went from orange to red. There was immediate danger and threat to Elowen. I had to take action immediately to save Elowen. I think the import of those is clear. The defendant told us that his entire mindset was saving Elowen, and in conjunction with those other things, it is abundantly clear the defendant took the stand today and told us exactly what his purpose was in saving Elowen. It had nothing to do with a burglary. It had nothing to do with extortion or theft by deception or any of these other things that Caitlyn was supposedly doing while remaining unlawfully in his home. The state would not concede that she was remaining unlawfully. The defendant had not, I don't think, called the police and told her she needed to leave sufficient to have her trespassed. She was there with her child. So we wouldn't concede that she was remaining unlawfully, although the defendant certainly testified that he wanted her out of the apartment. With regard to kidnapping, again, I think we'll get into more of this at the charge conference, but the defendant testified that, yes, over the course of the day, he had these suspicions that maybe someone was outside in the car, there was someone, there were lights in the window, and he didn't know if Caitlyn had brought anyone with her. But that was not his stated purpose in why he took the lethal action that he did. He was very specific and very clear that while these threats about money and other things are being made, after that third attempt, in his own testimony, a line had been crossed. He went from orange to red. Elowen was being hurt. I shot Caitlyn to save Elowen because Elowen was being hurt. That is self-defense or defense of another in response to the use of deadly force. That's 627.4.2a. That is not B, C, or D. I would disagree with counsel's interpretation of D. I think the wording of that is pretty clear, that it requires that the person who is using the deadly force believes that the other person is likely to use any unlawful force against the actor, not unlawful force against anyone while committing a felony against the actor. I think the other language in the statute makes it very clear where, even in B, the statute says is likely to use any unlawful force against a person present while committing or attempting to commit a burglary. D makes it very clear that the force is against the actor. It doesn't say against anyone in the home or make it clear that the force can be used against anyone while the felony is against the actor. That doesn't make any sense. So for all those reasons, Judge, I think the motion to dismiss at this stage should be denied.
Okay, thank you. Anything further, Attorney Kenny?
Nothing more.
Okay, once again, we're here. The first order of business relates to the motion to dismiss filed by raised by the defendant previously before lunch. We will get to the charging conference and jury instructions, and I will explain what that is in just a second. But with respect to the defendant's motion to dismiss, the motion to dismiss is denied. for the reasons articulated by the state. I would also reference State versus Perez as referenced by Attorney Spicer, and relating back to all of my arguments that were in the citations that were indicated at the close of the state's evidence, which was on Thursday, if my recollection is correct?
Yes.
Thursday? Okay, so I relate back to Thursday for purposes of the initial motion to dismiss, which was denied, and I would deny the defendant's motion to dismiss again at this time for the reasons stated previously and for the reasons stated by the state, not with respect to A through D, but at least with respect to the referencing of State versus Perez, 2025, New Hampshire 6. So motion to dismiss is denied. Excuse me. Now, with respect to jury instructions, for those who may not be familiar with this process, those other than counsel who may not be familiar with this process, sometimes this is referred to as a charging conference. The jury instruction process, what we're about to do, relates to the specific sentences and paragraphs that I am going to provide to the jury after closing arguments with respect to the law that applies to the case. This is the opportunity for counsel for both sides to describe and argue on behalf of their side what law should apply, what law I should give the jury as it relates to the instructions that are given to the jury. The jury instruction booklet that typically is used is a large 3-ring binder, and what we do in this process is we narrow that down to say what does the jury need to decide as part of this process. So it can be sometimes a lengthy conference, and that is why I sent the jury home for the day, so that we can have plenty of time to make sure that everyone has developed a sufficient record on both sides relative to the issues that we are about to discuss right now. Also, for the record, I previously gave the first half of my instructions to the jury before opening statements, and I'm going to come back to that in just a second. Next, I will state for the benefit of everyone that I did circulate a very rough draft of jury instructions to counsel at the end of the day on Friday, so that they would have the weekend to be able to review them and make their comments, be prepared to make their comments about what part of the jury instructions should be altered, what should be added, what should be taken away. And that's also what we're about to do right now. And there's one other thing I was going to say, but we can't finalize the jury instructions until we know exactly how the evidence has been completed. And now that the evidence has been completed, it gives the opportunity for everybody to make arguments about the appropriate way for me to instruct the jury at this point in the proceeding. So in terms of how we go through this, I know that we are going to take quite a few detours as is necessary as part of the process. But what I will indicate to counsel, I guess the first question I have is, in any case in which there is an extended period of time, read that to mean any case that lasts over a 3-day period, especially one that goes over a weekend. I guess the first question I have for counsel is whether or not there is a preference that I go back and read the first half of my instructions again, instead of just the second half of the instructions. I don't know if anybody has any position with respect to that. I have done it before where there's been a request that I go back and read all of the instructions from the beginning. Any comment on that, Attorney Duren or Spicer?
The state doesn't feel strongly about it, Your Honor, but I do think that out of an abundance of caution with the case of this gravity and with the length of time that has elapsed since the originals or the first instructions were given, it would make sense to deliver those again. Because I think there are a number of topics in there that would be valuable to deliver to them again with regards to credibility of witnesses, that sort of thing.
Okay, all right. Counsel?
No position, Your Honor.
No position? Okay. All right. Based on that, and I want to state in that regard that one of the dangers in doing that, of course, is that if they are going to place special emphasis on the part that they heard before, however, I think that risk is mitigated by virtue of the fact that it does contain, there's typical language in there that says, please do not single out any instruction for any special emphasis. So the fact that they're hearing a portion of it a second time, that risk is mitigated or ameliorated by virtue of the fact that there's a separate instruction saying, please do not place special emphasis on any one instruction. So defendant has taken no position. State thinks in an abundance of caution, and the court agrees with the state. I will read the entire amount of the jury instructions from scratch. I realize that they are lengthy, however, I do think in this case it is important. It just dawned on me what I forgot to say to those who have not been through this process before. So I'm taking one step back. The other reason why we do this, of course, is because counsel, experienced and competent counsel on both sides, want to be able to frame their closing arguments based upon the law that I'm going to give to the jury. So in other words, when they prepare their closing arguments, it is of great benefit and necessary for them to know what the law is going to be, how I'm going to instruct the jury, so that they can tailor their closing arguments to the instructions that I'm going to give. So closing arguments will come first, jury instructions second, but we're talking about the jury instructions now so that the closing arguments for both sides can appropriately be tailored to fit those instructions that they're going to hear after the closing arguments. So once again, that is why we're having this particular conference at this time. Okay, next order of business with respect to the draft that I circulated. First, the copy I circulated should have page 10. Any issue with respect to page 10, counsel? Okay, on to page 11. So now with page 11, I guess the first question becomes, and my question will go to the state, the way I've structured this, the way I've structured it, once I get to the bottom of page 11, would be to include the elements there. What the defendant has proposed as part of their instructions is to include the self-defense element as directly as part of those elements in the first recitation of the elements for the second-degree murder knowing charge. State's position with respect to the defendant's structural argument to place the defense of others element into page 11 and 12. Attorney Spicer.
Your Honor, just to be clear, are you referring to including the defendant did not act in self-defense as an element? Or are you referring to including the larger body of self-defense instructions at this point?
And that's whether we say self-defense or whether we say defense of another. Do I include that element, assuming that I give it, which I know we're going to argue about here in a second, but is that structurally, do you have an objection to structurally me putting it in there, not relative to factual support, but relative to the structural component, the architecture of the instruction, so to speak?
And again, Judge, just so I'm clear, when you refer to the architecture, are you referring to the greater amount of instructions on self-defense generally, and whatever versions that you might find appropriate, or are you referring to adding an element to each charge?
Do I understand your question completely? Do I adopt what Attorney Kinney proposed?
Well, I guess I'll address both.
Yeah.
In my experience, I think there's no wrong way to do it. I do think it makes more sense logically and structurally to get into the elements of the offense first and then self-defense afterwards. So here's what the elements of secondary murder knowing are, reckless in each charge, and then self-defense afterwards. That mirrors, I think, the way the case comes in with the state's case and then the defense's case. I don't have any case law for Your Honor on whether or not there's a right way to do that. So I guess the state's position is that if it were up to us, we would propose charges first, or elements of each charge and each offense first, and then self-defense afterwards. With regard to whether or not there should be, second-degree murder, the elements are cause of death of another, do so knowingly, and then number 3, not act in self-defense, if the court finds that's appropriate. I think the case law says that there's either way is appropriate. There's case law that makes very clear that a court's choosing to instruct just on the elements of each offense and then instruct generally on self-defense and make clear during that general instruction that self-defense instruction applies to all charges. That is satisfactory. That is not erroneous or in any way legally problematic. I know it's been done both ways. Adding an element is not legally incorrect. So I mean, I think the state was satisfied with the structure that Your Honor had in the rough draft, I don't think defense's interpretation on that, either of those two topics is wrong.
Okay.
That's what I would say.
Okay.
Judge, I think the case law, while it says it's not reversible error not to add as an element, the case law is clear that the court should add as an element. So I'm going to read from State versus DuPont, 165, New Hampshire 698. And DuPont references the framework outlined in State versus Soto, 162, New Hampshire 708. So in DuPont, they say, here then, it is enough to say that when the defendant is entitled to a specific instruction on both provocation and self-defense, which I understand that's not necessarily where we are here, trial courts should add disproving self-defense as an additional element of the offense that the state must prove beyond a reasonable doubt. So I think that the Supreme Court has indicated a clear preference. I think the reason for that is that it is the clearest and fairest way to instruct the jury. I think it becomes much more confusing to address self-defense kind of abstractly separately from the elements of the charged offense. The law is clear that when there is some evidence of self-defense or defense of others submitted, the failure to act in self-defense becomes an element the state must prove. And so the court should instruct that it is an element the state must prove in accordance with the settled law in State versus DuPont.
Okay, all right, thank you. Anything further?
No.
Okay. All right, and so let's go right there, Attorney Kettles, with respect to, let's assume that I'm going to grant your structural argument as it relates to where the elements apply. Okay? Let's assume that I'm gonna grant that where it should apply. So tell me, with respect to second-degree murder, knowing how you want the proposal, let me find it, that I've received from you or from Attorney Kinney. The one that I received indicated that the defendant did not act in defense of another.
Yes, Judge, and so just to make it clear, we did essentially start at the bottom of page 11 and submit an entire version on Sunday, which I trust the court received. Which
I have, B, which I thank you for, and I'm following right along.
Thank you. And so it should say, the defendant is charged with a crime of second-degree murder. The definition of this offense has 3 parts or elements. And then I think we track your language, except that we then add a 3rd element, and the defendant did not act in defense of another. Then there's the knowing instruction, which I believe is the same. And then, Judge, on page 2, 3, and the top of 4, we provide our proposed instruction on self-defense, and I can read it into the record, but I don't think it's necessary as we've submitted. I'm sorry, it's defense of others.
Yes.
When I say self-defense, Judge, please just assume I mean defense of others. I think it just makes the matter clearer to the jury if we use the phrase defense of others rather than self-defense, since we're not, at this point, we're not arguing that Mr. Duren acted in defense of himself, but rather he acted in defense of Ellen.
Okay.
And so we ask that the court adopt our proposed language on self-defense, which, or defense of others, which tracks the statute and I think accurately states the law.
And I know why you're rising, Attorney Schweischer, and we'll, please make an outline as I am, so that we can go through each thing step by step. I know why you're rising. I don't want to interrupt Attorney Kettles further at this point.
And Judge, I'll note for the record that our proposed instruction tracks the instruction that was given in another case in this court, State versus Nomar Ramos Rivera, docket 214-2023 CR 26. It also, I believe, tracks instructions that this court has given in, what was your case?
Green.
State v. Hunter Green. And then another case that Attorney Harding told me about but didn't tell me the name of. So I'm sorry that that's not very helpful. But
Koval.
perhaps the court remembers.
Koval.
Yes, and so I think it's the instruction that the court has used before, both you, Judge, and the prior judge who sat here. It's an instruction that's based largely, I think, on the language that the Attorney General's office uses when discussing use of deadly force by police officers. The standard is the same for people who are not police officers. They should be entitled to the same instruction. It's a correct statement of law.
And Attorney Kettles, just to follow along, I think it was just a typo, but with respect to the submission I assume that on top of page 2, that, once again, you're for defense.
Yes, Judge, anywhere I'm using self-defense, please make
Certainly.
that mean defense of others.
Certainly. Okay.
And I don't think the headings are read to the jurors, so
They are not, but they do get copies of these,
that's true, Your Honor.
so,
I apologize.
okay. Okay. Okay, once again, assuming for purposes of this discussion that I will be altering the structure to be that which was requested by the defense attorney Spicer. With respect to the entitlement of the defendant based upon the facts relative to any of the defenses,
Thank you, Your Honor.
any of the pure defenses, I should say.
First, just as to the characterization of we're only dealing with defense of another, I think defense counsel argued earlier with regard to burglary under 627-24C that their theory was that the defendant actually and reasonably believed that under their interpretation, Ms. Nafziger was going to use unlawful force against him, or use unlawful force against Ellen in the commission of a felony against him. I think that does bring us back into self-defense rather than purely defense of another if there's a felony being committed against him. So that's just a characterizational note.
And can I stop for a second? So with respect to 627-4, 2A, and referencing the argument that you made during the motion to dismiss, I would just point out, right, that A says is about to use unlawful deadly force against the actor or a third person. You've referenced Mr. Duren's testimony as it relates to the perception of force being used by Ms. Nafziger against Elwin. However, you would agree that he was not perceiving deadly force against her.
I agree.
Okay, I just want to make sure.
So with regard to what instructions the defense is entitled to at this point, the
Yes.
state's position is that the defendant is entitled to an instruction on 627-4-2A based on his testimony. And again, the import of his testimony. So first, Your Honor, I'll try to structure this. With regard to B, C, and D in 627-4, those subsections, the state believes that the defendant has not shown, and there is no evidence sufficient to meet even the low bar for a jury instruction. I believe the standard is some modicum or more than a mere iota. I don't have a case site, but I believe
Scintilla.
more than a mere scintilla, yes, that is my understanding of the standard. The defendant took the stand and told us exactly what his mindset was. He used those phrases that I quoted, and again, those are from my notes, but he said, in response to a question on cross-examination, he agreed that he shot the victim because she hurt Elwin. And that is the import of all of his statements. While the defendant certainly testified that over the course of that day, leading up to the murder, he had in his mind some suspicions about things that were going on, and that Ms. Nafziger was making threats against him and asking him for money and telling him that if he did not provide her with money or did not sell his car, she would do certain things or call the police or take his children away from him. His testimony is very clear that when it came to the point that he is trying to get everyone into the car so he can drive them all back to Hampton, he is attempting to remove Elwin from Ms. Nafziger's arms. She refuses. There are multiple attempts, and after the third attempt, he told the court and the jury that the line was crossed. Elwin was being physically hurt in front of me. The threat level went from orange to red, and I perceived an immediate danger or threat to Elwin, and I had to take action immediately to save Elwin. That is why he acted. He did not act, I think it is clear, by omission in his testimony. He did not act because he believed that Caitlyn was in the process of, was committing or about to commit a burglary by committing any other crime while remaining unlawfully in his home. I think that is imputing an intent to Ms. Nafziger that is not present. We don't have any specific testimony or evidence about whether or not Ms. Nafziger remained unlawfully in the home with the purpose to commit a burglary by committing any predicate crime. But I certainly don't think that that standard has been satisfied for purposes of a jury instruction particularly in light of the defendant's testimony. With regard to C, kidnapping, I know that there's been a lot of litigation about this, but while the defendant said today that he believed, or that there was some suspicion in his mind that Ms. Nafziger was going to kidnap the children, that's not what he told the police in his statement, and it's also not what he said today about why he actually committed the killing, why he pulled the trigger. Yes, he had these suspicions, but he called them really just suspicions. In that vein, Your Honor, I think the state of the evidence, as according to the defendant, is important to take into account here. At the time the defendant pulled the trigger, by his own account, Ms. Nafziger was sitting on the couch. The crime scene photos tell us that she had one foot up on the table. She was not wearing any shoes. The defendant, by his own admission, was between her and any knives that were in the apartment. He was between her and the doorways. She could not exit without going through him. She was unarmed. She had not threatened to hurt him or to hurt Ellen or to hurt Valen. Given all of those things, and what I have referenced multiple times now about the defendant telling us what his entire mindset was, there's no evidence that he killed Ms. Nafziger because he actually or reasonably believed that she was committing or about to commit a kidnapping. The moment in time that matters here is the time that he pulls the trigger. And at that moment, for him to merit a jury instruction on kidnapping and self-defense, he had to actually believe that she was committing or about to commit a kidnapping, and that belief has to be reasonable. And that's not what his testimony was, and it's not reasonable. There's not even a mere scintilla of evidence that would support that that's a reasonable belief if he held it. And his own testimony here today has told us that he did not. I think the same argument applies to subsection D about whether or not the defendant actually and reasonably believed that Ms. Nafziger was going to use any unlawful force in the commission of a felony against anyone, him or Ellen, however that statute is construed. The defendant's testimony today and his statement to the police was that Ellen was not, the victim did not threaten to harm anyone. For him to say now, at this stage, that he actually and reasonably believed that there was a likelihood that Ms. Nafziger was going to use unlawful force against either himself or Ellen is just not supported by the evidence, particularly in the commission of whatever felony. The defendant's claim that he believed that there was this kidnapping or that there was interference with custody going on, this other crime that I think will become relevant in a minute, I think is also not supported by the evidence, where for Ms. Nafziger to kidnap her own children, to commit the crime of interference with custody by taking them away or concealing them from the defendant, would require her to leave. It would require her to do something other than remain in his apartment holding the child. And there's no evidence that she did anything of that nature. And again, she had no car, she had no bus ticket, no family or friends close by. She was not wearing shoes, she was not dressed for the weather. The defendant's own testimony was that he shot her and he pulled the trigger because she refused to let go of her child. That is not her committing or about to commit a kidnapping. She's not running out the door into a waiting car. She's not taking Ellen and Valen and hopping onto a bus when the defendant's not looking. That's simply not what the testimony is. I'll reference the degree of force jury instruction here as well. The court included it properly in the rough draft. I think it should be there. Obviously, as it should in every case involving self-defense and deadly force. There is no evidence that the defendant actually or reasonably believed that he used only the right amount of force necessary to commit, to act in his own defense. Whether he's doing it to defend Ellen or himself, to defend a kidnapping or otherwise, Ms. Nafziger was wearing no shoes with one foot on the table. She weighs half of what the defendant weighs, or roughly half. She's significantly smaller. The defendant testified that he is a trained Marine. He's been through boot camp, he's been through infantry training. He has this martial arts training that allows him to disarm anyone. His own testimony was that Ms. Nafziger was holding Ellen although there's a dispute over this, according to the defendant, in the light most favorable to him, Ms. Knapsager was squeezing Elwyn, perhaps enough to make her shriek. We don't accept that that's what the evidence is or what the evidence shows or what actually happened, but that was the defendant's testimony to some effect. By his own admission, Ms. Knapsager was not armed. She did not have access to a deadly weapon at the time that he pulled the trigger because he had the only gun in the apartment. And he said the only knives in the apartment were behind him, some distance away. They were certainly not readily close at hand. He didn't say that. They don't appear anywhere in the crime scene photos. The defendant shot Ms. Knapsager in the head. He is, by his own admission, an expert marksman. He has trained hundreds or thousands of Marines on how to shoot their weapons and how to use those to hit their target and eliminate threats. He testified he didn't shoot Ms. Knapsager in the arm. He didn't shoot her in the leg. He shot her in the head because that was his purpose. He told us today that he absolutely did aim when he fired his gun. So I think the import is very clear. It was his clear intent that he executed to shoot Ms. Knapsager through the side of the head where her hair was covering the side of her head. That is not proportional, and there's no evidence that was only the degree of force that was necessary. There's no evidence that any rational juror or trier of fact could find that. So I don't think the defendant has met the bar or satisfied their burden to obtain a jury instruction on self-defense under any of these varieties. While I am making this rather lengthy argument, Judge, I'll just state, I think to wrap up, if the court is inclined to give an instruction on self-defense in the kidnapping version, it should be specific and it should include a definition of what kidnapping is. The defense has not supplied a definition of what kidnapping is, although they argue that it is not the definition that's contained in 633.1. I think they have rather pointedly not defined it. And I don't think it is appropriate for this court to leave that open-ended and essentially allow the defendant to define his own version of self-defense in the kidnapping version. If the court is inclined to give a self-defense instruction relative to kidnapping in 627.4, 2C, we think that the court should instruct the jury what kidnapping is and what it is not. That kidnapping is, and I think we'll reference the statutory definition, that a person commits the crime of kidnapping if the person confines another under their control, the person does so knowingly and acting with a purpose to hold the person for ransom or as a hostage, avoid apprehension by a law enforcement official, terrorize the person confined or some other person, or commit an offense against the person confined. And again, it's our position that the defendant has not satisfied any of these, given the testimony and the state of the evidence. If the court does instruct on the kidnapping self-defense variety, we also think the court should make clear what kidnapping is not, and that relates to interference with custody and 633.1-A. The court has the legislature has specifically laid out what kidnapping is and what it is not in terms of a parent and their child who is related by blood. It cannot be the case that the defendant can receive the benefit of a kidnapping jury instruction for behavior consistent with 633.1-A when the legislature has said that is not kidnapping in this situation as it applies to him or to Ms. Knapsager. He certainly can't obtain the benefit of that when the law clearly says that he is not entitled to it. And I think it's important that the jury know that to prevent some sort of issue with specific unanimity or failure to agree on a specific definition of what kidnapping is. I think I'll stop there.
Once again, thank you, Attorney Special. Once again, with respect to 627.4.2A, I think that there was one point where you argued that they were, that the defendant was entitled to that instruction in one place where.
I misspoke, Your Honor.
I
think that's what the defendant testified regarding, but given the degree of force issue and the proportionality of force and the state of the evidence with regard to that, I don't think he's entitled to that or any other.
So the reason the reason why 627.4.2A would not apply relates to the amount of force.
Correct.
Okay.
Bringing a gun to a fist fight, so to speak.
Understood. Okay. Understood. All right. So from my perspective, and we'll get further relative to the kidnapping issue in a second, but Attorney Kettles, with respect to, I don't think there's any issue with respect to A, correct?
That's correct, Judge.
So-
We're arguing that.
B through D?
Yes, B through D.
Okay.
And Judge, the state has pulled a single piece of evidence out of context to rely on, but I think the overall comport of the evidence is clear. And I'll quote what Mr. Duren said both on cross and on redirect. The goal was to eliminate a threat who was holding my child hostage in front of me and hurting her. That alone is enough to get defense of others instruction under D through E, but that's not the limit of the evidence. That's not the only evidence in support of the defense of others instruction. And Judge, I think most of the other arguments that the state has made has gone to their perspective on the strength of the defense, not on whether or not the sum evidence standard was met. The sum evidence standard has been met. The court stated that it had been met at the close of the state's case, and since then, even more evidence of defense of others has been presented. State versus Brooks and State versus Woodburn and many other cases cite the same standards. And for the record, Brooks is 2025 New Hampshire 12, and Woodburn is 175 New Hampshire 645. The standard is, quote, for there to be some evidence to support a defendant's specific defense, there must be more than a minutia or scintilla of evidence. The evidentiary support need not be overwhelming. State versus Brooks further explains, quote, when a defendant asserts a pure defense and there is evidence to support the defense, negating such a defense becomes an element of the offense that the state must prove beyond a reasonable doubt. We have held that an erroneous jury instruction relieving the state of its burden to prove an element of the charged offense constitutes structural error, and that structural errors require automatic reversal of a defendant's conviction, end quote. And again, State versus Brooks, when there is some evidence to support a pure defense, a trial court's failure to give a jury instruction on that defense is akin to failing to instruct on an element of the offense. And we have far more than a minutia or a scintilla of evidence here. That one quote, the goal was to eliminate a threat who was holding my child hostage in front of me and hurting her, is some evidence. The additional evidence, and I'm not going to go over it, Judge, I'm going to pick 7 or 8 kind of key points here. There's evidence that Caitlyn actually had a plan to take the children out of the state without telling Dustin. There's evidence that Caitlyn bear-hugged, restrained, and confined Elwyn and would not let her go. There is evidence, and by evidence, Judge, I mean not only Mr. Duren's testimony today, but also the evidence that the state presented through its recorded interview, as well as Ms. Palmunden's testimony. While restraining Elwyn, Caitlyn threatened to call the police and lie to them and say that Dustin had kidnapped Elwyn unless Dustin gave her money. Today he testified it was a significant amount of money. I believe the police interview talks about $2,000 a month. Today he testified about her telling him to sell his car, which is certainly worth over $1,000. And so there we've got not only the kidnapping and the unlawful interference with custody, but that's also where some evidence comes in that she remained. This is after he told her to leave over and over again and said, we're going, I'm putting him in the car, I'm putting him in the car, we're going. And she still sat there and she made these threats. Judge, that's burglary. That's purpose to remain in the home with the purpose to commit theft by deception, lying to the police, saying that he kidnapped Elwyn in order to get money, theft by extortion. If you don't give me money, I'm going to take your kids away and you'll never see them again. That is felony level unlawful interference with custody, trying to take the kids out of the state. It's a felony against Mr. Duren, and it's also burglary, purpose to remain in the home with a purpose to commit stalking, harassment, and a number of other offenses. An additional piece of evidence, while restraining Elwyn, Caitlyn said Dustin would never see his children again, that she was going to take them from him. Another piece of evidence, some evidence in support of this instruction, Caitlyn pulled and yanked back on Elwyn forcefully enough for her to scream in pain. I think the evidence has been clear that Dustin shot Caitlyn because she was doing these things. He has described this entire situation as being very intense, very chaotic. All of this stuff kind of building up to the moment when the line had been crossed, right, where his goal was to eliminate the threat who was holding his child hostage and who was hurting her. The fact that that's the moment at which he acts doesn't mean he's not acting because of all the other stuff that's happening. He's acting because of everything in combination, and that's the moment at which he can no longer just do this tug of war, right? He has to take further action, proportional action, because of the pain that's caused to the child. That doesn't mean he's not acting for these other reasons. And I think the testimony has also been that Dustin shot Caitlyn while she was still holding Evelyn. So while she was still restraining her, holding her hostage, about to commit a kidnapping, committing a burglary with the purpose to commit all these other crimes, and using unlawful force while doing so. Dustin's belief was reasonable. It was correct. She had a plan to kidnap the kids. His belief that she was going to do so was reasonable. And Judge, I think I've cited unlawful interference with custody, false imprisonment, false report to law enforcement, two other crimes that she remained in the home with the purpose to commit.
If I grant you 627.42B, do I have to then define burglary?
Judge,
And how long is that gonna take?
How long is it going to take?
Not with respect to the argument, but with respect to the instructions.
Yes, I think that, so, from a kidnapping perspective, the case law was supported in our memo, or cited in our memo, State versus McDonald, which I've referenced at prior hearings, which is 163 New Hampshire 115, make it clear that the court cannot limit what kidnapping is to the statutory definition, but it's something broader. I think that the court could instruct on burglary and on all of these different offenses, and that would correctly state the law to the jury if they added in that the state must prove beyond a reasonable doubt that he was not acting because he reasonably believed that she was about to commit a kidnapping, and the state must prove beyond a reasonable doubt that he did not reasonably believe that Ms. Nasker was likely to use any unlawful force against a person present while committing or attempting to commit a burglary. I think the court could then provide a series of examples of a purpose to remaining in the home with a purpose to commit a crime, and could provide a series of examples of what those crimes might be.
I mean, McDonald talks about the phrase forcible sex offense, which is not coextensive with aggravated felonious sexual assault.
Yes. And it said there, I think McDonald and the other cases that I cite in my memo make it clear that unless it says as defined in the statute, it's improper for the court to limit what the word means to the statutory definition.
So, by providing examples, aren't I in a way limiting?
No, I think the court could provide examples and then say, or any other type of burglary.
But that's a large list.
Yes.
Okay,
But
all
I
right.
think correctly instructing on the law may require a large list, Judge.
Okay, please continue. Thank you.
Yes, Judge. And the state is trying to argue essentially different interpretations of the evidence, maybe asserting that there is contradictory evidence, but that doesn't change the fact that the court must give the instruction. State versus Kavanaugh is a case we haven't discussed much yet, but it's 174 New Hampshire 1, a 2020 case. And the Kavanaugh was abrogated by Brooks to the extent that Brooks said, look, this is structural error. But the rest of Kavanaugh is still good law. And there it says, quote, to be entitled to the instruction, the defendant had only to demonstrate that there was some evidence to support it. She did not need to submit proof beyond a reasonable doubt that she acted in self-defense. And it said also, the defendant contends that the trial court unsustainably exercised its discretion because it decided the merits of her self-defense claim instead of determining whether there was more than a scintilla of evidence to support it. We agree. Although the evidence was conflicting, we conclude that there was more than a scintilla to support the defendant's assertion that she acted in self-defense. What the court's asking you to do is basically to decide, or the state's asking you to do, is basically to decide the merits of the claim rather than allowing the jury to do so as it's proper. State versus Woodburn, it's got some interesting language in it about how the jury can make various inferences about mental state, even if the defendant doesn't testify specifically about mental state, that I think are instructive here, but I'll also note that State versus Woodburn says, to the extent that testimony can be construed as contradicting other testimony supporting the self-defense instruction, any inconsistency was for the jury to reconcile, not the trial court. And the sum evidence standard does not require that the evidence presented by the defendant be uncontradicted. So Judge, I think we've got far more than a minutiae or scintilla of evidence here for the subsections of 627.4 B through D. And so the court must instruct the jury on defense of others.
Okay, with respect to C, my question, Attorney Kettles, with respect to C relates to NUCAS, N-O-U-C-A-S, at 165-146. And the issue the issue relates to the kidnapping issue, which is, I just want to make sure I understand the defendant's position. In Nukas, it appears that Judge O'Neill denied the instruction based upon, my phrase is that it wasn't a question of whether there was sufficient evidence, and it wasn't a question of the court making a credibility determination based upon the evidence. Instead, Judge O'Neill was affirmed when he refused to give the instruction in Nukas because it didn't have the legal predicate for it. And I guess that's why, now we're getting to the point of why I asked for the memorandum in the first place, as it relates to the kidnapping issue, and specifically the 633 1A, if I'm doing this from memory, relative to, the question relates to Nukas, and it relates to legally, not factually, but legally, is the instruction to be given based upon the specific facts at issue here. And I'm asking you that question, and I'll go back to the state with respect to their position as it relates to how this situation relates to the Nukas situation. Excuse me.
And Judge, let me make sure I understand. My recollection of Nukas is that it deals with a situation in which the defendant is presenting a theory of the case rather than a theory of defense. So in Nukas... No?
Not by my read. My read, excuse me, my read is that it was a theory of defense. However, the predicate in order to trigger the defense wasn't met. I believe the word any is italicized in Nukas at the relevant. I can get the pin site, but that in this case there wasn't any evidence that justified the theory of defense. And I could be wrong about that, but I think that's the number one thing I've been looking at. Are you factually, is the defendant entitled from a legal standpoint, not from a factual standpoint? But, once again, continue.
Judge, I'm not sure, I need to reread Nukas, but my notes on it indicate that in that case, he testified to different versions of events than the state alleged, and the defense of others would have been in regards to an offense he wasn't charged with. So he wasn't saying, like, I think in Nukas, let me just make sure I'm right. He was convicted for accomplice to armed robbery, and he essentially argued, I'm not going to get the exact facts right here, Judge, but he essentially argued, I was justified when I assaulted someone. And the court said, well, you're not charged with assault, so it doesn't really matter. It might not be assault, that's an example I'm using. It doesn't really matter whether you were justified in assaulting because that's not what you're charged with. Your being accomplice to armed robbery has nothing to do with defense of others. And so here, you know, he is admitting to committing the act, and he is saying that the act was justified. And so Nukas is not applicable because the defense of others resulted in the charged offense.
Okay. And so, sorry, excuse me. Sorry to make you get up again, Attorney Kettles. Once again, with respect to B through D, under McDonald, you're asking me to use the expressions with respect to B through D from a colloquial sense as opposed to a strict sense?
Yes, Judge, as it relates to kidnapping, we're saying that that cannot properly be limited to the elements in 633.1. And I want to be clear, in case there's any dispute, I'm not saying 633.1A applies. I know what the word consanguinity means, but that the court would be improper to limit the jury to considering the elements of 633.1.
But you're looking for a colloquial definition as it relates to kidnapping and to burglary?
I don't think that there needs to be a definition of the word kidnapping in State versus McDonald. There was no definition of the word forcible sex offense.
Correct, but they're using it in terms of I think they used a colloquial, the way in which it's defined, as opposed to a statutory definition. I could be off on the word colloquial.
my understanding is that the court just included the phrase forcible sex offense and explained our statute is clear, the language is not difficult for the jury to understand in McDonald.
Okay, all right, thank you. Okay, state's position based on that?
Your Honor, I think I'll refer to State versus Davidson, which was cited by the defense and the state, 163 New Hampshire 462. In that case, Supreme Court interpreted RSA 627(8) relating to use of force in defense of property. And there, they were concerned with the term unlawful taking, and they ruled that it is not limited to merely theft, quote unquote, as defined by statute. But the import of that is that it was not limited to theft because the term unlawful taking can include other behavior besides the statutory definition of theft, similar to forcible sex offenses, which can include a variety of different offenses. Kidnapping is not one of those. So what the court is saying in these cases is that we're not saying as defined by, because we are talking about a larger category of statutorily defined offenses. In Davidson, they made it quite clear that we're talking about the top of a funnel here, not the bottom of it. And so in this case, 627.42c specifically references kidnapping. 627.42b references burglary. Those are specific words relating to specific crimes that are defined by statute. I don't think it is appropriate, the state does not believe that it is appropriate to leave open the definition of those terms to a colloquial definition, which is inviting the possibility that the jury is going to make a decision on an incorrect definition of those terms. I think that's simply not appropriate, particularly in light of the situation. We're not talking about defining these offenses for purposes of a charge of kidnapping or a charge of burglary. We are talking about doing it in relation to the use of deadly force and whether or not that deadly force is justified. And as we make clear in our pleading, I think it's very clear and not arguable that the use of deadly force in self-defense is only available in certain prescribed circumstances, in a very narrow set of circumstances as defined by the legislature. What the defense is asking is to blow that up and allow the defendant essentially to define or leave open for the jury to sort of just on their own define in a colloquial sense, what does kidnapping mean, what does burglary mean. In a situation like this where deadly force is involved, the court should make sure that the jury knows what those terms mean and that they are agreeing on what those terms mean, whatever their verdict might be.
And Judge, the state's argument would ask the court to include language the legislature did not see fit to include, and would ignore the clear guidance in State versus Woodbury 172, New Hampshire 358. And the guidance in Woodbury says that when a statute includes the phrase as defined in RSA X, it is a term of art. But when the statute does not include the phrase as defined in, it is not. And so if the legislature wanted to, it could have made a statute that says a person is justified in using deadly force if he reasonably believes that a person is committing or about to commit a kidnapping as defined in RSA 633(1). We know that the legislature knows how to do that because it does so in a number of other statutes, including the one outlined in Woodbury, including 627(8), and a number of other statutes that I referenced before, the reckless conduct statute, and other portions of the justification statute. The legislature knows how to make something a term of art by saying as defined in a statute, and it chose not to do so here.
Okay. All right. You want to go to the, I've got my thoughts on that, but we'll keep going right now. Let's go to the defense's request relative to use what in this geographic part of the state is colloquially referred to as the NOMAR instruction relative to self-defense, what's been proposed by defendants relative to the NOMAR instruction. The state has proposed the self-defense as it relating to the 2011 criminal jury instructions. Am I correct? 85 or 2.
Proposed anything, I think. I don't know if that's what the court used.
You did propose.
We did.
Yes, back in September.
Oh, yes, I apologize. Yes.
Yeah, not recently, but back in
Okay.
the September filings.
Yeah, I think we referred back to the model instructions. Again, I don't think that those instructions from NOMAR are wrong, but I think different courts and different situations can instruct differently, but I think that the instructions in the court's rough draft are appropriate and track the law, track the model instructions with no deviations. I think obviously the instruction as proposed by the defense are more favorable to the defense, so in that sense, we don't believe that the court should give them, but I think either is appropriate.
Okay, thank you. All right.
And Judge, again, they're not wrong, right? The no more instructions are a statement of the law. I'll note that the model criminal jury instructions were actually drafted in 2010, and the defense of other statute has been amended since then. And so I think that in and of itself is a reason to give the no more instructions rather than one that a draft instruction not finalized that predates the most recent version of the statute.
Attorney Kettles, if I give the NOMAR instruction, so to speak, what's your position relative to the request from the state to use the degree of force instruction from Etienne?
Judge, I would argue that, I have a couple of arguments about Etienne. The first one is that, again, at least the case itself predates the amendment to the defense of other statute, and therefore the court there didn't consider the amendment to the defense of other statute. I also think it's important to note that Etienne is discussing a case where a person is, where the claim is that someone is about to use unlawful deadly force against the actor or third person. So there's this kind of built-in proportionality that needs to happen there, right? It needs to be deadly force. Deadly force can be met with deadly force. A slap in the face cannot be met with deadly force. But by contrast, the other three kind of subsections of the statute are things where the legislature has determined if this happens, it's okay to use deadly force. If there's a kidnapping, deadly force is proportionate. If there's a forcible sex offense, deadly force is proportionate, right? This is very different, this subsection, than the rest. There's no requirement that any force be used at all. And so I don't think that there can be a proportionality assessment when there's no requirement that any force be used at all for the defendant's actions to be justified under the law. And I think that kind of recognizes the split-second decision that someone needs to make when one of these serious, they reasonably believe that one of these serious offenses is about to occur.
Okay. Want to proceed to the other two elements? Excuse me, the other two crimes, Attorney Spicer?
If I may just touch on the degree of force, Your Honor.
Certainly.
I certainly don't think it was the legislature's intent to allow the use of deadly force where there is no force used or no degree of deadly force used in any of these other contexts besides the one in 627(4)(a). In the defense's reading of this, under B, there's a burglary. If I remain in someone's home unlawfully or enter by going into someone's apartment and I tell that person, I'm going to steal your wallet. According to the defense's interpretation of that, if I don't touch them, I don't brandish a weapon, I don't wave a knife in their face, if I just say, I'm staying here, I'm not leaving, and I'm going to take your wallet, they can shoot me in the head. I don't think that comports with the law. There's significant case law on this. Etienne, most of all, cites State versus Mayo as well, 167, New Hampshire, 443. Says a person can defend against what he reasonably believes to be the imminent use of unlawful, deadly, or non-deadly force by another, and can use the degree of force that he reasonably believes is necessary for this purpose. I think that's kind of built into the law there, so I'll address that and leave it there. Your Honor, I wanted to move on to what next? I apologize.
Is there anything else before we move on to reckless conduct in child endangerment? Anything else anyone wants to say for purposes of the record?
No, I don't think so.
No, Your Honor.
Okay. Okay, I just want to make sure everybody's developed, before I start making rulings on those, I just want to make sure everybody's got their factual record, their record relative to the arguments that have been made.
I think the one thing I would add, Your Honor, tacking onto the discussion of whether kidnapping should be left open as a colloquial definition, I think it's important for the court to instruct not only on what kidnapping is, but what it isn't, to avoid a situation where the jury, mistakenly or not, believes that the defendant was acting because he thought Ms. Nafziger was going to take his kids away and take them away to Minnesota, which would legally constitute interference with custody rather than kidnapping, because the children are related to both individuals by blood. Ms. Nafziger could not legally be charged with kidnapping for doing that. I don't think it's acceptable to run the risk that the jury, because of the testimony, mistakenly acts on that and acts on a mistaken understanding of what legal definitions apply here. So if the kidnapping instruction is given, our position is it should not only define what kidnapping is and that the defense should be held to which particular theory of kidnapping under the statute they believe the facts support, but also what kidnapping is not, so that there's no danger that the jury is making its decision on a mistaken interpretation of the law.
Okay. Right now it's 2:10, and at some point we'll take a break. And I guess one of the things I'm soliciting input on right now is, should I make some initial rulings right now and have folks proffer their requested instructions as the best use of our time as it relates to what we're doing right now before a break, before we get to the other two charges? If you understand what I'm saying.
I don't think there's a significant dispute for the other two charges, right? We would once again add that the element of defense of others should be added, but I think it perhaps makes sense to get through everything so that we can get the court's actual instructions.
Sure, I want to leave enough time so the council can assist with getting the instructions before 4 o'clock is what we're going to be doing here. I mean, let me make it clear. I'll work all night, but you won't have the benefit of that relative to your preparation of closing arguments.
However the court wants to handle it.
What's that?
However the court wants to proceed.
Let's go with the reckless, let's go with second degree reckless. I want to hear argument about whether let's do second degree reckless, and then we'll take a break after that. I'll make some rulings, then we'll take a break. So I guess my question relates to the defendant version includes the defense requested version includes the phrase depraved heart, whereas the state's version, I believe, does not, based upon the jury instructions relative to the manifest and extreme indifference to human life. If I'm wrong about that from the state's perspective, let me know, but I believe that under the model jury instructions proposed by the state that the phrase depraved heart was out
That's correct, Your Honor. I don't believe it appears
in the model instructions. And so I did note that it was present in the defendant's version that they requested. So I just want to hear, I want to make sure everybody has said whatever they want to tell me relative to that specific issue.
I think it's inviting a degree of confusion by adding another somewhat obscure legal term that does not appear in the model instruction.
Okay.
Judge, I think it's been used in other cases with similar charges, and so it's appropriate to use here.
Okay.
And it was upheld in other cases.
Okay, so once again, Attorney Kettles, going back to the NOMAR instruction, you indicated that your position is that is a correct statement of the law. I understand that it's been used previously, but you also indicated as part of your argument that it had been used relative to justified shootings?
Judge, I think that the no more instruction, I believe, was crafted by attorneys Wines and Mayo, and I think that they did extensive review. The footnotes are in my original instructions that were submitted of kind of how the Attorney General's office has handled claims of self-defense or defense of others in the past. And so those footnotes, Judge, are in the original instructions that were proposed instructions that were submitted. Let me find when those were submitted. Back on September 3rd.
Okay.
And so I essentially, it's on page 3, Judge. I think it's essentially an argument of what's good for the goose is good for the gander, that if that's the correct statement of law, and it's the standard that the Attorney General's office applies when dealing with officer-involved shootings, that should be the standard of law that the court applies for someone who's not a police officer.
Your Honor, the Nomar case involved testimony from an expert in the use of force. So the use of force was an issue in that case in a way that it is not here. I think those jury instructions were tailored to that specific case. There is no such factual predicate for them in this case, where the defendant is, described the situation that we're in. It did not involve the same or similar facts, similar arguments about those facts, no expert testimony on the use of force here. So I think that, while those instructions were found to be appropriate by the court with regard to that case, that doesn't mean that they're appropriate for this case.
Okay. All right, thank you. I will make some rulings on the record, and then we will take a break, and then I'm going to, during the break, I'm going to be starting to solicit from counsel their specific instructions on a few things. So I will be adding, from a structural standpoint, I will be adding the act in defense of others element to the individual components as it relates to the second-degree murder and knowing and second-degree reckless. In other words, I'll be adding the part that says that the defendant did not act in defense of other. I hereby grant that request of the defendant. With respect to the actual defense of others component, I'm going to deny the defendant's request to use what is being referred to as the Nomar instruction. With respect to specific uses of individual defenses within 627.4 Roman numeral 2, with respect to A, I think that it's been established that A is not applicable under the circumstances. With respect to B and D, the court is mindful of the directive from the Supreme Court relative to the court's weighing of credibility as it relates to the previously referenced Kavanaugh case, and also the Brooks and Woodburn case. The court is mindful of the court's job not to comment on the merits of the case and to not impermissibly act as fact finder as it relates to Brooks and as it relates to Woodburn and the other cases mentioned. With respect to B and D, however, I'm focusing on the phrase likely to use. The issue relative to likely to use, there's a difference between, under the statute, a difference between A, which uses the phrase is about to, and C, is committing or about to commit. Whereas B and D, specifically the legislature chose to use the phrase is likely to use. Not whether the person is committing or is about to, but rather with B and D, the focus is the adverb likely to use. So based upon the evidence that has been presented, I'm denying the defendant's request with respect to B and D. And again, I am not substituting myself in the position of fact finder. I'm not commenting on credibility, but I'm focusing on the phrase is likely to use, both with respect to B and D, as opposed to is about to use or is committing or is about to use, which is a different sentence structure used by the legislature in A and in C. I am going to grant the defendant's request with respect to C. Obviously, we're not talking about a forcible sex offense here. We're talking about kidnapping. So I'm granting the defendant's request as it relates to 627.4 Roman numeral 2, lowercase c. I'm aware of nucus as it relates to whether there's a legal predicate or not. I believe that the defendant has established that. So what I'm ruling is that B and D are not permissible. I am granting C, and I do think that there needs to be some definition of what kidnapping, what we're talking about as it relates to kidnapping. So I am going to solicit from both parties their phraseology as it relates to kidnapping. Under the law, a kidnapping is blank. In other words, I'm going to grant 627.4 to C. Under the law, a kidnapping consists of, or a kidnapping is defined as, and then I need to have something as it relates to what a kidnapping is. And if the state chooses to propose what a kidnapping isn't, I will view that in the context of what the state, overall of what the state is proposing and what the defendant is proposing as it relates to how 627.4.2C will be applied under these circumstances. And I'm also going to adopt for purposes of ruling right now, I will adopt the Etienne phraseology as it relates to the degree of force, deadly force versus non-deadly force. So that's what those are the rulings as it relates to what we've got to this far. Finally, I will not be using the phrase depraved heart. I will be using the second-degree murder, the remainder of the second-degree murder reckless component with including the manifesting an extreme indifference to the value of human life. The rest of that, but not including the depraved heart sentence. So with respect to this point in the instructions, any questions from the state as it relates to instructions at this point? Attorney Spicer. Okay, Attorney Kettles.
No questions, Your Honor.
Okay, 15-minute break. And anything that I can receive relative to kidnapping, we'll proceed with the other counts. But anything I can get relative to kidnapping will help not just me, but help you. We'll get this done. We'll get this done by the end of the day. Thank you. We'll have a 15-minute recess.
All right.
Thank you. Please be seated. Sarah, is this me? No, do I? On the desk. Nothing there, nothing.
I don't know what it is.
Okay, thank you. Okay, I've been advised that I am receiving something relative to kidnapping.
Yes, the state filed, I think, what the court asked for, proposed definition of kidnapping and what kidnapping is not.
Okay. Okay, thank you. Thank you. Moving on to reckless conduct with a deadly weapon. Attorney Spicer, or Durant, whoever's doing this.
Your Honor, the state was satisfied with the draft instructions the court circulated. I think they accurately instruct on the law related to that offense. I believe the court has already indicated that you're going to add the additional element of the defendant did not act in self-defense, and that's already been ruled out. But otherwise, the state has no issue with the defense or with the instruction as written.
Okay. Okay.
And Judge, I think all we did was add the fourth element and then take out some of the additional language regarding deadly weapon because I think, and serious bodily injury because here the manner in which it was, you know what, Judge, actually we're fine with the instruction that gave with the addition of the fourth
Adding the additional element?
Yes, Judge.
Okay. So I will amend reckless conduct with a deadly weapon, charge ID ending in 222C relative to adding the state's burden to prove that element beyond a reasonable doubt of defense of another. Okay, moving on to endangering the welfare of a child, the attorney's pleasure.
Again, Your Honor, the state has no issue with the instruction that is circulated by the court. I'll note specifically that the state believes the court correctly identified the distinction between the dual intents there, with purposely violating the duty and knowing with respect to endangerment. So we do believe that is a correct instruction.
And position relative to, three options. Do I force, three options. Do I force counsel to argue that there's a duty? Number one, do I request that counsel stipulate that there's a duty? Or three, do I simply enter a finding that there's a duty? For purposes of this draft, for purposes of this draft, without making an order, I posited that it would be within my province to indicate simply, without going overboard, simply to say, under the law, the court has determined the defendant owed a duty of care, as stated in the instructions. So, from your perspective,
I don't know if that's in dispute. I think it's appropriate to certainly take it out of the jury's hands as something they need to decide and make it clear that that element is not an issue. We're happy to stipulate. I don't know where defense counsel is on that.
So Judge, I think it would be error for the court to issue a finding on an element. That is the province of the jury. And the defense is not going to stipulate to an element. It has a right to hold the state to its burden on this element. So we would ask that that language that the court has, it appears in bright in mine, it may be different coloring in yours, but at the bottom of page 15, under the law, the court has determined to the end of the page that that be removed.
okay, and, okay, if I, based upon the defendant's arguments, which I acknowledge, based upon that, Attorney Cattles, do you want me to do you want the court to define duty of care under the circumstances? And once again, for purposes of the record, in case it's not clear, I believe both counsel already agreed that there is no model jury instruction. There is no model jury instruction that we are aware of relative to this. Am I correct? Attorney Duren's shaking her head yes. So,
Correct.
okay.
Judge, we submitted the proposed instruction that we would ask the court to give.
And the one, just so I'm clear, the one requested by the defendant does not include a definition or reference relative to the duty component?
Correct, Judge.
Okay, so, all right. Okay, any argument? Any argument on that?
No, Your Honor.
Okay, so with respect to endangering the welfare of a child, Attorney Kettles, if I strike the one that was on my page 15, if the pagination has not been changed, the one that was circulated to counsel, if I strike the sentence that begins under the law, the court has determined, which I'm doing that, is there anything else in my wording that, and if I add not in defense of another, if I add that as an element, if I strike the comment about the court finding a duty, number one, and number two, if I add the not in defense of another element, both of which I'm going to do. The next question, I guess the next question that really I'm getting at next is, in the statute for which there is no model jury instruction, it includes two different states of mens rea. And what I attempted to do and how I wrote it was reference the purposely with respect to violating the duty and the welfare with respect to the effect upon the child. So I understand that the defense has requested their instruction, but if I add defense of another, and if I take out the finding of a duty, does the defendant have any position as it relates to the relation of the mens reas, the relation of the two separate mens rea components to the individual action components of violating a duty and the endangering of the child?
Judge, our position would just continue to be that the proposed instructions that we filed on multiple occasions are the best instructions in which we've given in this case, based on in re and K.
Okay, so my I understand your position. My observation is that the one requested by the defendant does not match up the mens rea with the individual actions, which, if I grant the defendant's request in that regard, my concern is that I'm not adequately providing the jury with the necessary instruction under the circumstances. I'm still considering whether to grant the defendant's request, but I'm trying to find out if you don't want there to be a reference with respect to the mens rea component and the actus reus component.
Judge, I believe our proposed instruction discusses both the mens reas.
Your Honor, I think the court's instruction accurately captures this issue in the statutory language, and I'll cite State versus Bordner, 150, New Hampshire 504.
Okay.
That I think speaks to the interplay of those two, but I think is appropriate to instruct as the court is doing.
Okay. Okay, thank you. All right, moving on relative to, that concludes essentially the defendant's draft. Moving on to my draft. Again, I'm moving up the defense of another components. I'm moving that up so that it is coming directly after the elements for second-degree murder, knowing, go right into the the defense of another component at that point. So now back on my draft, I'm at page 20. My inclusion, the paragraph starting with multiple charges. Position on that? Multiple charges, alternative charges, position from the state?
No position, I believe that's acceptable.
Okay, Attorney Kettles?
Judge, with the multiple charges, I guess my concern is that if the jury finds that Mr. Duren was justified in causing the death of Caitlyn massacre, then that should lead to a not guilty verdict on the other charges as well, as any proportionality or any other kind of argument would surely mean that he was justified in his actions that would otherwise constitute lesser offenses.
The state didn't disagree with that. Certainly the jury, if the elements are different, there's no overlap, there's no lesser included, there's no automatic function of law where the defendant would necessarily have to be innocent of other charges if acquitted on either of the murder charges. I think they are separate and distinct. There are scenarios where the jury perhaps could find the defendant not guilty of murder, but certainly still guilty of reckless conduct or endangerment of a child.
And I think, okay, thank you. Attorney Kettles, any response?
I think our point is that if the jury finds that the state has not proven beyond a reasonable doubt that Mr. Duren was not justified, then that would result in acquittal on all four charges.
I think I'm explicitly positing that possibility by virtue of including a element in each of the individual charge definitions relative to the fact that the state has the burden with respect to each of those individual elements. So I think that takes care of that. The justification defense is essentially inserted into each of the element definitions in each of their constituent sections. So I'm going to leave that in as is. Okay. Alternative charges, Attorney Kettles.
Same argument regarding the element, right? The only element I think meaningfully in dispute as to the two alternative charges is the acting in defense of another.
Okay. And the rest of it, I hesitate to use the phrase boilerplate, but with respect to the remainder of the boilerplate, so to speak, obviously it is extremely important. By saying that, I do not mean in any way to not indicate how important it is under the circumstances. However, when I use that phrase boilerplate, I'm simply saying it's the same usually from one case to the next. So I don't know if there's any specific challenges to any, or questions with respect to that.
No, Your Honor.
No, Your Honor, just, I guess, request at some point that we could see the verdict form.
Certainly. No, I should have sent that, I'll get that to you instantly, soon. Okay. Anything else right now with respect to the instructions, Attorney Spicer?
No.
Okay, and Attorney Kettles?
Is now the time to discuss the definition of kidnapping?
Yes.
Then yes.
If we're ready to, then yes. Yep.
So, Judge, the state just a minute ago propounded a proposed definition, and I want to be clear that we continue to maintain our objection to defining kidnapping for all the reasons that we discussed before in terms of McDonald and Woodbury and the other cases cited in our motion. But I think the specific definition proposed by the state, or any definition that's kind of limiting us to the statutory elements, is an issue because the statute says that Mr. Duren would be justified if he reasonably believed that Ms. Knapsaker was committing or about to commit kidnapping. And so I think that it's instructive to look at the case law on attempted kidnapping. In State versus Casanova, 164, New Hampshire 563, the court explains that a person commits the crime of attempted kidnapping when, with a purpose that kidnapping be committed, he does or omits to do anything which, under the circumstances as he believes them to be, is an act or omission constituting a substantial step toward the commission of the crime of kidnapping. And Casanova also explains that the state was not required to prove the elements of kidnapping under RSA 633(1) to sustain the charge of attempted kidnapping. And so I think here where we have the possibility that Mr. Duren is justified if he reasonably believes that someone is about to commit a kidnapping, he doesn't need to reasonably believe that each element of the kidnapping statute was met. State versus Bean, 153 New Hampshire 380. The Supreme Court says, we noted that the attempt statute requires the state to identify the intended offense, this is an attempted kidnapping case as well, but does not require the state to plead and prove the elements of the intended offense. Since an attempted crime is by definition a crime not completed, the state could not plead, factually identify, and prove the elements of the intended offense as if it had been carried out. We therefore held that the state was not required to allege in the indictment a statutory subsection of the attempted offense. To convict the defendant of attempted kidnapping, the jury was required to find that with the purpose of the crime of kidnapping be committed, the defendant did or admitted to do anything which, under the circumstances as he believed them to be, is an act or omission committing a substantial step toward the commission of the crime of kidnapping. So the state's proposed instructions, first of all, I think their reference to essentially 633(1) Roman 1A is confusing and inappropriate, but second, it doesn't adequately capture that Mr. Duren would be justified if he reasonably believed that Ms. Knapsaker was about to commit the crime of kidnapping based on Bean and Casanova.
So with respect to the defendant's position that the existing phraseology in the jury instructions is sufficient as is and don't define kidnapping further at all, am I correct?
Yes, Judge.
Okay.
That it should track the language of the statute because the legislature has not referenced 633(1). It would be improper for the court to limit kidnapping to the offenses in 633(1).
And I'm reading what the state has filed.
when the court's ready, I'll have more argument.
Certainly, just a second. So Attorney Kettles, I guess here's my next question. If I don't define kidnapping, in the instructions, and then 10 minutes into deliberations, we get a note from the note that says that a certain juror has been picked as a foreperson. And then 30 minutes after that, we get a note from the jury that says, what is a kidnapping?
Then the court should instruct, use your common sense everyday definition of what a kidnapping is. I think that's what the legislature says, that's what the statute says. Judge, I'll note, in addition on the state's proposed instructions, that they've narrowed it down essentially improperly just to kidnapping and not to about to commit a kidnapping. And then by using that paragraph, it is also important to note certain behavior that does not fall within the definition of kidnapping, followed by a lengthy sentence. Judge, that is certainly including language in 627.4 that the legislature did not see fit to include. And there's many sites, I put them in my pleadings, about statutory interpretation. The court cannot add this full page of definitions that the legislature did not see fit to include in 627.4. The state is trying to use a different statute that's not referred to in 627.4. This is not a term of art. The legislature knows how to create a term of art. It knows how to refer to other statutes. It did not do so here. And so the court is limited. It cannot add language the legislature did not see fit to include, and that's what this entire page that the state submitted is.
Okay, and was that also the further argument?
That was the further argument, Judge.
Okay, all right.
Your Honor, I think the court has already expressed that it is appropriate to define kidnapping to address the very situation that Your Honor just brought up, that the jury may very well wonder what kidnapping means. The most appropriate definition is the one contained in RSA 633.1, and that's what the state has included here. The state has not changed that definition or added to it or detracted from it. We believe that is the appropriate definition, and again, we believe it is appropriate to define kidnapping for what it is and also what it is not. We did include in brackets that a person commits the crime of kidnapping if they confine another under their control, do so knowingly, and the person acts for the purpose to, and then we include each of the 4 scenarios in subsections A through D. We would suggest that only those scenarios which contain some supporting evidence would be appropriate to give. We included them all here just for completeness. But I don't think that there's any supporting evidence that the defendant reasonably and actually believed that Ms. Nafsiger was committing a kidnapping by confining Elwyn to avoid apprehension by a law enforcement official, so we don't believe it's appropriate to include that. That Ms. Nafsiger was confining Elwyn to terrorize anyone, or that Ms. Nafsiger was confining, or that Mr. Duren believed Ms. Nafsiger was confining Elwyn to commit an offense against Elwyn. So really the only one of those 4 scenarios that we believe would be appropriately included would be the first one, hold the person confined for ransom or as a hostage. That's the argument that the defense has been making. So we believe that one would have some support, and that is the only one of those 4 scenarios that should be included. And again, with regard to statutory interpretation, the state submitted a pleading with multiple citations regarding statutory interpretation as well. It's our position that it is appropriate to define kidnapping in this scenario.
And so once again, Attorney Spicer, with respect to McDonald 163-115, the statutory interpretation of defense of others includes the phrase forcible sex offense, which there's discussion in McDonald that it's not coextensive with aggravated felonious sexual assault in McDonald. Would you agree with me relative to that? So even though the McDonald says use the regular phrase forcible sex offense without getting into defining it, the state's position is that that's okay with forcible sex offense, but it's not okay with kidnapping?
I agree, because there's no crime of forcible sex offenses. This is going back to Davidson, where we're talking about an unlawful taking, and it's okay to have unlawful taking, and that is not a reference to a statutory definition, but it includes more than one potential crime. Here, there's a reference to kidnapping, which is statutorily defined. It is not a broader category of crimes.
am I also correct that the state's position is that once you answer the question that you just, once you answer the question you just asked relative to the forcible sex offense versus aggravated felonious sexual, forcible sex offense versus aggravated felonious sexual assault, once you get past the McDonald question, and once you say that we need to define kidnapping, the state's position is also that the legislature hath spoken relative to defining kidnapping to also include what kidnapping is not.
Yes, and I think we're talking specifically in the context of kidnapping for purposes of justification of deadly force, where I think the context of that is very important, and then the interplay between 633.1, 633.1-A, and interference with custody, 633.4, indicates that whatever kidnapping is, we know what kidnapping is not. And Ms. Nafziger legally could not kidnap her own child for behavior consistent with interference with custody. And there is a great risk that, based on the testimony and the evidence, that the jury may act on a mistaken belief of the law that that is what kidnapping is. And that we want the jury to understand what kidnapping is and what it is not.
Attorney Spicer, I haven't made my mind up yet as it relates to this issue, okay? So my next question for you is, if all that's true, am I invading the province of the jury as it relates to giving this specific instruction as it relates to the elements of the general offense? Am I impermissibly, does that instruction that you're asking me to give, does that impermissibly invade the province of the jury? And or does it essentially does it mandate a specific outcome which is impermissible under the law?
No, I think the court would be simply, defining the boundaries here, and then the jury is free to make its own decision about whether things fall on one side or the other. The court is not instructing as to any of the elements or whether or not the evidence has satisfied them in favor of the state or otherwise. The court would simply be giving a definition of what kidnapping is.
Okay, thank you.
The way the legislature has written the statute, the only guidance that the court can give is the word kidnapping or about to commit a kidnapping. That's what the legislature has said. The legislature has explicitly omitted an interplay between 627.4 and 633.1 or 633.1A. The legislature knows how to connect those statutes, and it chose not to. And the court cannot ignore that deliberate choice of the legislature. The jury should be instructed on what the statute says, and then from there, it gets to use its own interpretation of what kidnapping is. I'll note some without that is our position. I think that's the correct reading of the statute. But some additional issues with the state's proposed definition is that the final paragraph creates a risk that the jury will believe that Ms. Nafziger could not kidnap her own child, full stop. And that's incorrect as a matter of law. And then also, I do think that evidence has been presented that Ms. Nafziger acted with the purpose to terrorize Mr. Duren through her actions. So again, the court cannot create an interplay that the legislature does not say exists. The court cannot instruct on the definition that the legislature has not given in 627.4.
And for the record, again, legally as opposed to factually, that's why I issued the order I did a couple Fridays ago asking for instructions. I know counsel already knows that, but I knew we were going to get to this point. I didn't know. I take that back. I didn't know we were going to get to this point. My assumption was we were going to get to this point where we are right now, and I wanted to make sure that we had adequately briefed the issue. And I know counsel has competently and with great care, counsel has competently briefed the issue relative to both sides. So that is why I wanted to focus everyone on what I did a couple weeks ago, which is why we're here right now. Okay, anything further, Attorney Spicer?
No.
Attorney Kettles, anything further?
No, Your Honor.
Okay, all right. So once again, I'm going to make my mind up. I'm going to take a brief recess. I'm also going back to the, I'll make a final decision. We're all set on reckless conduct with a deadly weapon. I'll make a final decision as it relates to child endangerment. And I'm going to check one thing, and I'll make a decision as it relates to this specific issue. And again, I haven't decided what to do, but Attorney Kettles, if I grant the state's request, it's hostage and terrorize?
Yes, Judge.
Okay, all right. All right. We're getting there, counsel.
Okay, all rise.
Oh, and I'll get the verdict form disseminated right now, also during this break. Be back when I can. Thank you.
Willis County Superior Court is in recess.
Okay. Once again, for those uninitiated in this process, the reason this takes so long is because we need to make sure that we have all the evidence in, number one. And number two, the reason we're doing this is to make sure that counsel can adjust their closing arguments based upon how they know that I'm going to be instructing the jury, which happens after the closing arguments are conveyed to the jury. So I think the final issues before the court that needs to make a decision on with respect to the endangering the welfare of a child count, I'm going to maintain the version which is included in the draft that was circulated, with the exception of removing the court making a finding relative to duty and inserting a element relative to the need for the state to disprove that element beyond a reasonable doubt. Excuse me, the fact that the defendant did not act in defense of another, that the defendant acted in defense of another. That I'll add that element as a fifth element. I'm taking out the recitation to the court making a finding relative to duty. Relative to the legal issue relative to definition of kidnapping, I thank the state with respect to its prompt ability to submit a document relative to the definition which is being advocated by the state. Let the record reflect I've gone back and reviewed State versus McDonald again, 163 in New Hampshire, 115, relative to an analogous, not necessarily on point because it's a different nature of the defense, but to an analogous situation, and I'm going to grant the defendant's request relative to not providing a specific definition as requested by Attorney Kettles. I reviewed the state's request again. I reviewed State versus McDonald, and brief shepherdizing relative to running that case forward for any negative authority on the applicable point. I did not see any, so as a result, I am going to grant the defendant's request relative to leaving the term undefined or using a non-statutory defined meaning. Am I correct by the way you're advocating, Attorney Kettles?
Yes, Judge, meaning undefined.
Okay. I've also circulated the proposed special jury verdict form. Any comments with respect to the verdict form?
Your Honor, the only comment I have is a suggestion that perhaps with regard to the two murder charges, it might be helpful to include knowing or reckless, just so that there's no confusion on which charge they're
Okay, anything else?
considered. No.
In addition to that suggestion, Your Honor, we would prefer that not guilty be first and then guilty.
Okay, any objection relative to including knowing and reckless relative to parentheses?
No.
And switch not guilty and guilty?
Yes.
Any objection on that?
No.
Okay, court will grant that request and will interpose or will flip around the guilty and not guilty relative to that. Anything further, Attorney Kinney, on that?
No.
Okay, all right. Attorney Spicer, what have I forgotten?
I don't think anything.
Attorney Kettles, what have I forgotten? I know everybody. I know people have maintained their objections. Everybody's maintained their objections. Are you satisfied with your record, Attorney Spicer?
Yes.
Attorney Kettles, are you satisfied with your record?
Yes, Judge, the one thing I noticed, there's been a lot of discussion once we, I don't think that there will be, but once we review the final draft, if there is any concern at all. Notwithstanding objections we've already made, but I'll address it immediately, once I've seen it in writing.
Okay, so, just so I'm clear, nothing I've forgotten, and I mean, I'm gonna get to the next 12 hours procedure in just a second, but nothing else I've forgotten, and you're satisfied with your record? at this point?
Yes.
Same thing?
Yes, sir.
Okay, so, what I will do in today's modern society is email addresses aren't that difficult to figure out. We already have everybody's email addresses. I will get this concluded. I'm not sure if it'll be concluded before 4:30, 5 o'clock. I'll get it concluded and get it emailed to folks. My only order, I'm gonna be emailing it directly to all 4 council. The only thing I'm gonna say is do not email me back. Do not email me back because I'm going to decline to respond. If there is an issue, if there's a typo issue, I encourage council to email each other and leave me out of it. If there is something, if any of my rulings are unclear, I hope they're not unclear so you can prepare your closing arguments. But if there is a drastic issue which needs to be addressed, we will address it before closing arguments tomorrow. We'll get that fixed, but hopefully I've provided enough instructions right now relative to my rulings so that you can prepare for closings. I will email directly because my excellent monitor will be, I'm not gonna get it done in the next half hour, but I want to take the time that it needs, that it deserves under the circumstances, under this important case, and very good lawyering by both parties relative to the issues at hand. Clerk Restaurants, anything I'm forgetting from your perspective? Okay.
Do you want to ask them back at 8:45 tomorrow, just so we can see if they're?
Can we, 8:45, just to be safe? 8:45, in other words, I'll be ready at 8:45 if we do have to address anything. If there is nothing to address, then we can proceed right to closings at 9 o'clock? Okay? Okay? Okay, all right. All right, thank you for your work today, and that's why we didn't hold the jury, and we'll see everybody at 8:45 tomorrow. Thank you.
All right.